Well, thank you very much, everybody, for coming and joining us on this beautiful evening outside and a beautiful evening inside in this magnificent hall. My name is Stuart Alford. I'm the chair of the Employed Bar Society here at the Middle Temple, and it's my great pleasure to introduce our panel for this evening and to host what I'm sure is going to be a fantastic discussion about an extremely timely topic. It's my pleasure to introduce Dr. Alan Brener, who is the Deputy Director of the Centre for Ethics and Law at UCL. And we are hosting a panel tonight to talk to us about AI and its impact upon employed bar. We welcome you all here. We also welcome about 65 people online as well. So it's a fantastic turnout, and thank you very much. I have one other duty, which is to perform my cabin crew responsibilities and tell you where the emergency exits are and the toilets. So the emergency exit is out the back doors that you came in through, out and to the left. Should there be a fire, I certainly hope there won't be, and we're not expecting one. If you have a different kind of emergency and need the toilet, they are also out through the back door and across the passage, downstairs for the men, upstairs for the lady. With that, I suppose I now hand over to the pilot, or as it's AI, should I say the co-pilot, my attempt at an AI joke. Please fasten your seatbelts. Dr. Alan Brener.
Thank you very much, Stuart, and a welcome from me and the panel here. Many thanks to Middle Temple for hosting this event. It's a fantastic place. I'll speak a little bit about it in a moment. As you know, this is co-hosted between Middle Temple and UCL Centre for Ethics and Law. And we're fortunate here, very fortunate to have the director, because I'm just the deputy director. We have the director here, Anna Donovan. I have to make a confession before I start. This hall fills me with terror. I did my bar exams, the actual exams here. I don't know how many of you've been called to the bar, but some of you may actually have done your bar exams here as well, on long tables and benches. It's probably all changed now, probably much more modern, but in this ancient hall. But triumphing over my fears, I just want to say thank you very much for all our panelists. I'll introduce them in a moment. We've got a good turnout, as Stuart said, both here and online, which is fantastic. I would just mention before we go into the order of precedence that this hall, some of you may know, is dates back to the time of Queen Elizabeth I. I think it's 1560. It survived fires, it survived bombing, and it is quite magnificent. The inn, as you know, based around the Temple Church, goes back to something like the 12th century. Unfortunately, the records of the inn were destroyed during the Peasants' Revolt in, I think, 1381. But the rest of this hall survived, certainly from the time of Queen Elizabeth I. The hall, as you may know, was the place where Shakespeare's Twelfth Night was first performed on these, well, maybe not these very wooden floors, but certainly on floors that are represented here. Back in sort of the 1602. So you're in an amazing building, very historic, with some fantastic pictures of the Stuarts and even a Hanoverian over there too. In terms of how we're going to organize this, we've got this wonderful panel here. What I've suggested to all of them is each one speaks in turn going down for about 5 minutes, and then we'll open it up for discussion. And if the IT works, we'll try and take some points from the online audience as well. So please come up with your questions for discussion. At this point, I will stop and introduce all the speakers in one go, as opposed to breaking it up. So if I start no particular order, at the far end with Alison Cottrell, CB. I used to work for Alison a few years ago. She she's the director of the Financial Services Division within the Treasury. And I came across her there. And then when she became Chief Executive Officer, first for the Banking Standards Board and then for the Financial Services Culture Board. And she's now a non-exec director, amongst other things, the Link, the ATM network, and she specializes in corporate governance and professional services. Orla, sitting next to me over here, Professor Orla Linsky. She holds the chair of law and technology at UCL's Law Faculty of Law, specializes in digital regulation, and she's editor-in-chief of the specialist journal, the International Data Protection, Privacy Law Journal. So a complete expert on a whole range of things to do with IT. Then going on to Professor Philip Morgan, University of York. He's Professor of Private Law there. He focuses on the law and AI and publishing. He was co-editor of the Cambridge Handbook of Private Law and AI, which came out last year. And he's the law lead on the York's multidisciplinary doctoral training centre on safe AI. Saints. I don't know who made that one up, but it's brilliant. And he's called to the bar here at Middle Temple. Then moving on, we've got Flora Page, KC, who is 23 Essex Chambers. Flora, if some of you, like me, watched the public inquiry hearings for the post office scandal, you would have seen Flora in action many, many times. And so she's been heavily involved in standing up for the dreadful things that happen to postmasters and mistresses. She's a specialist in corporate governance, culture, and ethics. And most recently, she's been appointed as chair of the Institute of Business Ethics, and she's a member of the board of the Legal Services Board. Then we've got, I'm seeing who's next, Dr. Raphael Reams, who's on the advisory panel for the UCL Centre for Ethics and Law, and he's a compliance expert, particularly he's employed at BMW, and Reggie recently arrived in the UK. So have I missed out anyone? I don't think so. Have I got anything wrong? I hope not. Let's move on. First thing, I'm just going to go down the table here. Orla, do you want to kick us off?
Thank you, Alan, and thank you, Anna, for the invitation to participate this evening. We've got a very diverse panel with lots of different perspectives. So as you heard, my expertise lies predominantly in digital regulation, thinking about how the law regulates new and emerging technologies, but also how those technologies regulate us and our behavior. So I am definitely the person here who is at the furthest step removed from legal practice, and therefore I'll confine myself to some very general opening remarks to kick things off. And so in thinking about this and the impact of generative AI and the opportunities for generative AI at the employed bar, I think first of all, we can consider the potential impact of this technology on the legal sector as a whole. And I think there are many ways in which we could envisage that trajectory. And then I'll move in a kind of a second part to consider some of the more specific challenges and kind of dilemmas that this may raise for in-house counsel. So turning first to the impact on the legal sector as a whole, I think it's interesting that when we are talking as lawyers about AI and in particular large language models, that we are typically approaching this from the perspective of substitution. To what extent can we continue with the status quo, and where in continuing with the status quo can we imagine AI systems substituting for existing human tasks. And so this is, I think, one way of thinking about this. But there is, of course, an alternative way, which sees this technology as creating a kind of a more fundamental rupture in the structure of the legal business, in the legal sector, if we consider it as a market. So by background, I'm also a competition lawyer. And here we might start to make comparisons with other areas or other sectors. You could think of farming at the beginning of the Industrial Revolution and how that kind of fundamentally changed as a result of technological development. Or we could think more recently about the impact that widespread access to the internet had on certain trades like travel agents, which only exist now in very kind of bespoke circumstances. And the query then really is which of these two models you subscribe to, or whether the substitution model or the fundamental rupture, or whether in reality, widespread substitution may kind of evolve towards something that seems, in the end, more like a fundamental rupture. And here, first of all, we could start to think about in-house counsel and in-house roles, which I think will need to be more responsive to the changing ways in which businesses operate. And here, I think the primary dynamics are that businesses will likely become far less siloed insofar as data, which was currently kept within particular departments or in particular aspects of businesses, will operate and be available horizontally. And that will probably lead to more kind of top-down changes in terms of processes and procedures within corporations, which will likely mean that the role of in-house counsel will need to be kind of responsive to that change, operating in a more horizontal way, if it is not already doing so in-house. Then, of course, we know that in-house counsel interacts on a very frequent basis with external counsel. And here, when we think about law firms and the existing kind of pyramid structure, there is a real question about whether or not in the legal profession, that is one of the most kind of vulnerable areas for this kind of automation substitution, particularly for those who find themselves, as we probably many of us have already been, at the base of that pyramid, where a lot of tasks that trainees would complete within law firms are most susceptible to automation. The first draft of a letter, drafting of an email, document review, these types of document synthesis tasks. But this again raises a question for firms about how you create a future trajectory of leaders if you have a kind of a reduced base in that pyramid. But we also know that law firms are under immense pressure from external counsel in order to change the current business model insofar as at the moment, for example, the model for billing is one based on input, the time of staff, rather than output, the outcome of the legal advice. And so that may lead, I think, to a change in our way of doing business. In other areas of law, if we look beyond the corporate, the trajectory is far more difficult to predict. So on the one hand, legal futurists, although I'm not sure if that's the best way to now describe him, but such as Richard Susskind, would say that there's a huge opportunity here in terms of access to justice, that we might be able to clear backlogs and resolve low-level, incontentious, or with disputes that have low levels of contention, if we could agree between ourselves what those are, through automation, thereby freeing up valuable resources in terms of finance and also capacity to deal with the more kind of high-stake disputes. At the same time, if more and more litigants in person rely on automated tools like large language models to represent themselves, if we see simply a legal environment that becomes more saturated with information, the quality of which we cannot control, then this also creates huge pressures on workload. And so how those two things resolve is not quite clear to me. So I do think the first kind of set of issues pertain to the sector, the legal sector as a whole. The second set of issues go to the day-to-day challenges of integrating large language models and other forms of AI into legal practice. And here, and I really curious to see what colleagues on the panel think about this. It seems to me that counsel will face kind of competing imperatives, because on the one hand, we have obligations of integrity as lawyers to produce high quality and accurate work. On the other hand, there is an obligation to make legal services accessible by keeping down costs and availing of efficiencies where they're available. So there's a very kind of delicate balance there to be struck between the kind of, I guess, the prohibition of use of AI and the imperative to use it. And here I haven't seen any very clear legal guidance steering the professions on that, although people may contradict me on that, or update me rather. Specifically, I want to mention 3 challenges at this point, which others may pick up on. The first concerns the output quality of large language models. So we're very familiar with the idea of hallucinations or inaccurate output. And so there is a query there about how those inaccuracies can be minimized. We know that even from providers within the sector like OpenAI, they say that the inaccuracies are a feature of these systems, not a bug. So we'll never be able to eliminate them completely. But also, and I think this is as relevant maybe for the legal profession, is that the output produces median content. It inclines everybody towards the mainstream. And often people go to lawyers for excellence, for something that is beyond average. And so there is a query there about how lawyers should receive a tool which, you know, brings you to the statistically most likely next word in a phrase, or the statistically most likely next formula, and what that does to creativity in the profession more generally. There's also a data governance challenge. In order for outputs, in order to maximize the potential for an output to be accurate, you need to be working with extremely high quality data. And this often means that you need to limit the context windows, limit the training materials that a model has been produced drawing on, which may include integrating confidential client files, which may include integrating legal, documents and files that are specific to the legal profession. But there are queries there about the legality of the use of that content. Is it protected by IP? Are there other rights at stake, like in my field, data protection or individual rights? And is that information accurate and up to date? So I think this raises a whole kind of spectre of new issues that are really pushed to the fore by LLMs. And then a third query or a challenge I think the council may face is to what extent it is possible and desirable to develop these tools in-house, which may confer a competitive advantage, but may also be a cost. It does give you more control over things like the data governance. But it also puts you in a place of kind of strategic dependence on third-party providers. Maybe this is very alive to me today because we've just had a day without internet at UCL Laws. And, there's this query about working with the lights off or working where a third-party provider increases its fees dramatically or changes the terms of its services dramatically. And how, if you have that kind of strategic dependence on those third-party providers, the legal profession can navigate that. So I'll leave it there, but these are just some opening remarks to set the scene.
Thank you. It's a real pleasure to be back in Middle Temple Hall. I have some very warm memories of my time here as my qualifying sessions, and I didn't sit in the exams here, so maybe my memories are slightly different from a generation that did. So thank you very much for the very kind invitation. It's a real pleasure to give this talk tonight. And in this talk, I'm going to focus on large language models, or LLMs. They're a type of generative AI which focuses on text generation. They're trained on vast amounts of data, and they use probabilistic models to predict and generate text responses. The Bar Council guidance, which has been produced, compares them to a very sophisticated predictive text system. Now, the range of uses for LLMs within legal practice is vast, and such technology offers great potential, but also new dangers. If you want a really good introduction to the field, a good survey mapping the life cycle of legal work and potential Gen AI uses,
I'd really recommend the Singapore Ministry of Law's Guide for Using Generative AI in the Legal Sector that was produced this month. It's currently a draft, but it's a really good introduction to the field. Now, such technology offers great potentials, but it also generates new dangers. Now, as an experiment to give this talk, I decided to consult both ChatGPT and Gemini on what they might include on a talk to employed barristers about Gen AI and legal practice and its advantages and risks. And both platforms with very little prompting structured talks for me, which I decided not to use. But I'm sure they would be much more engaging and interesting than mine. ChatGPT even provided me with speaker notes, which perhaps self-interestedly said, frame AI not as a threat, but as a tool, just like junior counsel, diligent, quick, but needs supervision. Now, both systems produced a list of opportunities and risks and limitations that were broadly correct and similar. They highlighted opportunities such as efficiency gains, better insights through pattern recognition, disclosure analytics and litigation, accessibility, consistency, and quality control. And in terms of risks and limitations, both systems brought up hallucinations and errors, risks of fabricated cases, citations or facts, problems of bias and fairness, embedding systemic biases, confidentiality and data security problems, privilege risks, accountability and professional standards issues, and also the problem of over-reliance, where there's an erosion of critical thinking and legal judgment. But there are, of course, other risks which were not mentioned by the systems. IP and particularly copyright issues come to the fore. Also liability or insurance coverage, AI sycophancy, which can lead to a party's arguments or prospects being overvalued, the anchoring effect impacting on legal judgments, and also for the potential for out-of-date data or insufficient distinguishing between English law and other jurisdictions. Now, I want to focus on my short talk on hallucinations. And the reason for doing this is I believe it to be the most pressing issue for practitioners now. So what are they? In short, they're false output, such as fake cases, citations, and incorrect quotations in law. Now, AI models hallucinate because they're trained on a certain amount of data, and they're prompted to respond to queries with the most statistically likely answer. Questions which are asked, are outside of the data the model knows, can lead to the system responding with incorrect information, and their probability-based approach sometimes lead to the system finding faulty patterns and creating fabricated information. How often does this occur? Well, it's context dependent, but it's frequent enough for the divisional court in the case of Indi that they were able to produce an appendix of cases from across the common law world of AI hallucinated fake cases being presented to courts. Now, before coming, I decided to get Gemini and ChatGPT, again, to draft a critical evaluation of a particular legal issue I know quite a bit about. And it wasn't long before I started to see the hallucinations. The hallucinated citations looked remarkably convincing. And it was only my subject matter expertise that allowed me to quickly spot the errors. If I was working outside of my field of expertise, I would be quite easily fooled without careful checking. And I should note that even specialist legal AI systems with access to training data, which includes law reports, can hallucinate. Now, many of you will be familiar with the case handed down in May of the King on the application of Frederick Indi and the London Borough of Haringey. In this case, claimant's counsel cited 5 fake legal authorities in the grounds of judicial review. And in addition, the documents incorrectly set out the statutory duty. This resulted in a wasted costs order and a referral to the regulators for both the counsel and the solicitor concerned. The case was then referred to the divisional court alongside a second case under the court's Hamid jurisdiction. And in the second hearing, Dame Victoria Sharp, giving the judgment of the court, stated that the referrals arose out of actual or suspected Gen AI use, resulting in false information being put before the court. This decision should be compulsory reading for all barristers and bar students. The President of the King's Bench Division highlighted the professional duties of legal representatives to check the accuracy of Gen AI outputs by reference to authoritative sources. And she made it clear that this applies both to the lawyers using AI and also lawyers who rely on the work of others who've done so. But also, very importantly, it was made clear that those with leadership responsibilities need to take effective measures so that those providing legal services understand and comply with their professional and ethical obligations and duties in using AI, and that in future Hamid hearings, the profession should expect the court to inquire if those leadership responsibilities have been fulfilled. Dame Victoria Sharp stated that where lawyers do not comply with their duties to a court might respond with one of the following: referral for prosecution for the offence of perverting the course of justice, contempt proceedings, referral to the regulator, strikeout and cost sanctions, and also public admonishments. Now, given express references to negligence in both IND decisions, although not to the tort of negligence itself, it's most likely that in future professional negligence litigation, the failure to adequately check AI cases will be considered professional negligence. Now, this is a very brief introduction to the area, and I'm very much looking forward to our panel discussion.
Thank you. Well, I think I'm probably here to talk about the cautionary tale that is the post office, and what happens when tech and the law goes very badly wrong. So I'm certainly very happy to do that, because I think the legal community has yet to really take on board the scale, the enormity of the scandal and what it means for lawyers. Lawyers of every type let the postmasters down in the most deplorable way. And that's not just in-house lawyers. There has been some focus on in-house lawyers, and some of the in-house lawyers were particularly egregious. But in fact, it was in-house, external, it was criminal, it was civil, it was judges, it was barristers, it was solicitors, it was everyone. The Law Society, for example, has said nothing about it. They are too concerned about damaging the professional reputation of solicitors. They fail to realize that saying nothing is damaging. And it means that when lay people look at the conduct of lawyers in the post office, they ask themselves, why do we need lawyers? What are lawyers for? And I think that's particularly relevant in the context of talking about AI, because as we're coming to appreciate very rapidly, AI is able to do so much of what typically, traditionally, lawyers have done. So here's the thing. One of the distinguishing features of a human lawyer is their moral compass and how that translates into their professional ethical compass. And so that is absolutely fundamental to what makes human lawyers important and why human lawyers should, I hope, remain important. So I'm going to focus on ethics, and I'm focusing particularly on in-house counsel's ethical role before coming back to AI, because AI systems will only be as ethical as the lawyers overseeing them. For the most part, ethical failures in lawyers generally, not just in-house, come down to prioritizing the duty to act in your client's best interests ahead of your duty to act with integrity. Now, there's great pressure on lawyers to do that, of course, and the pressures can be even greater in-house. So I'm going to look at the example of Susan Crichton, who was general counsel at the Post Office in the summer of 2013. That was a crucial moment when Post Office was going into cover-up mode, in effect. And the pressure put on Miss Crichton was undoubtedly very, very heavy. This was spelled out in a note that Paula Venables made for herself, a little note to self, in which she said of Miss Crichton that she was possibly more loyal to her professional conduct requirements and put her integrity as a lawyer above the interests of the business. Now, that's a direct quote, and it was a criticism. That was what Paula Venables thought was a criticism of her general counsel. So there was undoubtedly a lot of pressure on Miss Crichton. She was in receipt of what some of you may have heard of if you did follow the inquiry, the Clark advice, which stated very clearly that post office convictions based on horizon evidence may be unsafe. And that was because the expert witness from Fujitsu, Gareth Jenkins, his credibility had been fatally undermined due to a failure to reveal bugs in the system. Now, Miss Crichton, after discussion with Miss Venables, produced a board paper which downplayed and minimized the possibility of unsafe convictions and said nothing at all about the expert witness, Gareth Jenkins. So that was her first sort of semi-whitewash, if you like. But then she was excluded from the meeting at which that paper was tabled by the chair. And after that, she disappeared from the business under cover of an NDA. So she did almost nothing to bring the Clark advice to the attention of the board. After she had departed, a different member of the in-house team briefed external lawyers to alert the post office's insurers to the problem and the potential for litigation due to the unsafe convictions and the expert witness problem. So the insurers were told and the board were not. So that's a key moment, isn't it, in any in-house counsel's career, when they want to, when there's a risk that's so significant that insurers ought to know about it. And the idea that you have that risk in mind, that you know that's such an important risk, the insurers need to know about it, but you don't tell the board, that obviously is a key moment. So here's the thing, and this gets to what is the problem with prioritizing the client's best interests ahead of your wider duty of integrity? Was it really in the post office's best interests? So that urge to cover up, to help your client to look away, that urge, it's not just in a cover-up situation, it happens much more normally when we're just trying to normalize or ignore a small problem. Something perhaps in a new AI system, which, you know, it's not the end of the world, but we're normalizing it, we're looking away, we're not going to worry too much, for example, about the possibility that the data going into that system is coming from sources which make it likely that it might be producing outcomes which are prejudiced against people from minority groups. Let's not worry about that data problem. Let's look away, because it wouldn't be in the client's best interests to flag that up and make an issue of that. Well, would it not be in the client's best interests? Certainly anyway, start with your integrity. And so your integrity requires you as in-house counsel to examine whether it really is in your client's best interests to do something which is acting against your wider professional integrity. And so I think what we have to try to do as lawyers, but certainly as in-house counsel, is we have to try to think through the full effects of what our clients want to do with AI. And we have to try to think of the people who may be affected if we look away or facilitate a problem with it. And we have to exercise our counterfactual reasoning. And the reason I say counterfactual is because as matters stand, AI cannot help us with complex what-if questions. And that is exactly what legal minds ought to be able to deal with, is the what-ifs. What if this? What if that? What if this data that's come from this source produces outcomes which are discriminatory and prejudiced? What if? And let's look at that. Let's really analyze that. And it may be putting a bit of grit in the wheel, but that's what you're there for. And we need to use our emotional intelligence too. That's the other part of being a human lawyer. If you know one of the postmaster's personal stories and what they've been through, you can ask yourself this: could someone like them be damaged by what my client wants to do with this AI system? And keep that person in your mind. In this way, we support our clients to use AI ethically, I hope. Before I finish, can I urge you to read Ryan McDonough's short blog. It's called "When No One Speaks Up, Should a System?" And he's a blogger who's quite prominent on LinkedIn. And he came to a talk that I did with Lee Castleton, one of my clients. Lee is a truly inspirational figure. And he prompted Ryan to think about how AI could support in-house legal teams to be more ethical. And his piece is short, it's very practical, and there's lots of great ideas, and it's far better explained by him than me. So, as I say, I urge you as an in-house counsel with an ethical compass to read it.
Well, thank you. And probably it's good that we sit in this order because I am an in-house counsel. So I will try to, with what I'm saying, to mitigate your concerns, obviously. So what I want to focus on is a little bit the use of AI in practice as I see it in some of the companies. So what is important to me also to say that on front, that obviously my comments do not refer to my employer in specific, but just some general remarks and views that I have how AI is used by various companies. So there was a famous politician in Germany, and as you can hear from my accent, I am from Germany, who said back in the days when the internet was introduced that this thing will not stay for long and will disappear over time. I think that was a mistake. That's very clear, and I think there should be no doubt that AI is here to stay as well. So how is AI being used by in-house counsel and compliance department and legal departments that I see? So first of all, and I hope that already mitigates some of those concerns that were raised, I see a differentiation in the kind of bots that are used. For example, I know a company that uses a policy bot for the wider business and legal bots just for the compliance and legal departments. So the policy bots then have as their source all kind of policies, etc., for, let's say, invitation to events, hospitality, and those things. And those policy bots are then available for the wider business, and they only have as policy, let's say, those general policies. And then there are legal bots who are only available for the legal and compliance departments and not for the wider business. And they have as their sources, for example, competition law, guidelines by the authorities, and those kind of things. So there is a risk-based approach for low-risk use cases and higher-risk use cases, depending on the audience and depending on the source. Obviously, there are some other challenges that were just mentioned. How is that being tried to solve in practice? With regards to confidentiality, we do what we always do as lawyers. We put it in a contractual wording and put that responsibility on someone else. In that regard, most of the time to companies like Microsoft, etc. When it comes to reliability, obviously it is important that a human being is always kept in the loop. And therefore we use disclaimers for the bots that this is the first indication, and they need to check, the wider business need to check the answer, for example, that they have from policy bots by themselves. And with that, there's also the third point, source identification. Obviously, those policy bots, for example, that I have seen, they then refer to the sources, and then you can click on it, and then you can basically look it up for yourself. So that are some of the ways how it is being tried to mitigate those concerns. It's not perfect, but probably it will develop over time.
But what is also important for me, as we always talk about challenging and concerns, is the benefits. And for us in-house departments, it is very useful because it frees up our time. We live in a world where I do not know any government that comes up with less regulation. It's always more. I think the only government is probably Argentina with Mr. Milei, who comes up with less regulation. And at the same time, companies have challenges, economical challenges. There is no budget for more and more lawyers, rather less. And you need to somehow solve all that. And there, AI is just simply something that helps you. It doesn't replace a lawyer, it helps you. And that is a huge benefit that I see. And another one is, especially at in-house departments, it can help you in formulating answers to the wider business that are audience appropriately. So for example, when an answer to an engineer is different to an answer to a salesperson. And when you know obviously the legal basics to the respective questions, it just helps you to formulate those answers. So in general, as I said, it's pretty clear AI is here to stay. I think the success, both in the use of AI, but also regarding some of the concerns, ethical concerns that were raised, doesn't really, in my view, depend on AI itself, but more on the training on AI and on the culture on AI that is for us to form altogether.
Thank you. And the application of AI, as we're hearing, is a big issue in all sectors. It will affect some sectors more than others. It will absolutely affect the professions, and it will absolutely affect a profession in which words really matter. Now, we've heard a lot about the opportunities, which are clearly huge. Information becomes more accessible, more quickly, more cheaply, implications for competition. And all of this is destabilizing. It's disruptive. It poses challenges. And among those challenges are the applications in a new context of professional and ethical frameworks and values. Now, clearly, and just following on from something that Bora mentioned, if an organization doesn't have a clear ethical framework, a clear set of values, that's a bigger set of problems which need to be sorted out well before it thinks about how it applies AI. But just thinking of some of the aspects, just a couple before I come on to talk about the culture, because I think that is something which really is slightly different in this world, the importance of organizational culture to in-house teams when they're thinking about their roles and responsibilities. But just picking up on a couple of those ethical aspects and thinking, and Flora, that was a very powerful statement there in terms of the honesty and the integrity. And we often hear, we often read about AI as a junior member of the team, taking responsibility for the junior, which is true to some extent, I guess. I mean, it's a very well-read and creative junior. It really wants to be loved by you, and it only lives for the moment. But it's not really a colleague, is it? It's a tool. It doesn't have common sense. It has huge working memory. It has huge data access. It has massive processing power. And it can use this in a probabilistic manner to produce answers which are coherent and plausible, but not necessarily correct. Which is where, as we've heard, we need that human in the loop, because that's where the honesty and the integrity and the accountability that underpins the legitimacy of this profession sits. And if you lose that, you lose the legitimacy, you lose the reputation. And while this may change at the moment, it appears that as humans, we are less forgiving of errors committed by AI than errors committed by humans. So if we don't have that human in the loop, our organizations will run huge reputational risk. And the second aspect I just want to pick up on is the competence, because as professionals, it's no good having honesty, integrity, and being incompetent. You know, being well-meaning is not good for clients, customers, society in this role. And here it's competence, not only in how we use AI, how legal teams use AI, but how the rest of the business uses it, how suppliers use it, how third parties use it. We have to have an understanding of that to exercise the role. And also, I was going to say the longer term, but it's actually medium term, maybe even shorter term, maintaining the competence of the profession. Again, this is not a purely legal law profession issue. It's for every profession, but how to maintain that, how to maintain continuing professional development, maintain entry-level competence at a time when the roles will be changing so quickly. And the final point, just in the sort of the values ethical framework side that really stands out for me as an observer, you know, I'm not a lawyer, but as an observer and working with in-house teams, the issue of independence, the pressure to have things done more quickly all the time. No team will be completely impervious to this, and maintaining that space for judgment, the critical judgment, independence will be crucial. So thinking of how this affects how in-house teams work as teams, as parts of a business and as parts of a profession. There's a couple of observations. One is the importance of the lawyers, the legal teams being part of creating, reviewing AI policy for their organizations. This has to be part of a cross-team exercise, and it really needs all professions, all sources of expertise to be involved. But however good that policy is, however complete it is, however beautifully drafted, and AI will produce you a great one, it's not the policy that matters, it's the outcomes, it's the behavior. Now, there will always be some individuals in every organization who will act badly and know they're acting badly. But in most cases, for most firms, the problem isn't the bad actors, it's the poor behavior. It's the people who don't comply, who don't follow the letter or spirit of the policy or the rules, because sometimes they don't know them. Sometimes they don't care. Sometimes they see other people who don't seem to care. They make mistakes, they have different incentives, they take shortcuts, they have targets, or they think the policy is stupid because it was clearly drafted by someone that doesn't understand AI. And at times, like the Swiss cheese metaphor, you know, when all the holes line up, those unintended errors line up, they go straight through, and the organization ends up in headlines in a way it didn't want, to the absolute detriment of the customers that organization serves. So as in-house legal teams, the behavior of everybody in the organization is paramount. And people behave differently in different environments. We're very, very sensitive to group norms. We care. We pick up really quickly what's tolerable within an organization, what's admirable, and what sort of behavior particularly is shameful. We really want to fit in. It's such a basic human driver. And if the culture, the way that things get done in an organization, is not conducive to using AI professionally, then AI will not be used professionally, however good the policy is, however tight the rules are. Culture was something which came very much into the spotlight in the financial services sector in the wake of the global financial crisis. And I know it's been very much a focus within the legal profession, but just, I think, three quick observations from that time working with financial services firms that I think may have relevance in a wider context. The first thing I point out is the absolute importance of an environment which facilitates and encourages speaking up and challenge. It's a key line of defense, especially in an environment which is as novel and quickly evolving as this. And in the work that we did in the organisation that Alan mentioned, we worked together in something which was called the Banking Standards Board and then widened out to become the Financial Services Culture Board. We did a lot of work on speaking up. And what came through was when people were asked, why did you not challenge? Why did you not speak up? And this may be because something's wrong, or it may be because something could be done better. Two reasons given, we fell into two sorts of buckets and both equally weighted. One fear, one futility. If I say something, something bad will happen to me. If I say something, nothing's going to happen, so why should I bother? Why should I take the risk? The golden question, in a sense, the key question for me in any organisation, in which I think any board would want to know, and any in-house legal team, I think, should want to know, is if you talk to employees across the organisation, and you ask them, did you want to speak up about anything over the last 12 months or whatever time period you want to specify? And then did you speak up? And those two parameters themselves don't matter, but the gap is absolutely important to tell you what is happening within your organization and how that gap changes. We want learning organizations. We want innovative organizations in this space to realize the benefits. We want resilient organizations, but we're not going to have those if people don't want to put their hands up and say something and challenge and contribute, or if we don't listen. The second point, and following on from that listening bit, is the leading by example. Something that is not just about people at the top of the hierarchy, but it's about all of us, any of us who have influence within our organization, our groups. And we know in our heads the importance of leading by example, but we're often just not very good at it. And if I think of some safety cultures, health, aviation, you will be familiar, I'm sure, with, there are checklists before an operation, before takeoff. And the thing with checklists is they need to be done by the most junior member of the team. Why? Because the senior members of the team will do shortcuts. They've done it so many times. They know, in quotation marks, they're not going to make mistakes. So it's the junior that needs to do it. And the senior members of the team, how we lead as influential people in an organization is crucial, because what leaders say will shape culture to some extent. But everything that they do will shape that culture. And when it comes to AI, when it comes to demonstrating that honesty, integrity, to checking the accuracy, to exercising the judgment, which the AI cannot do, that's where that example has to be consistently set out. And thirdly and finally, being open and sharing both what's being learned, sharing good practice, but also sharing what hasn't worked, which is really hard, but is often the most valuable thing. And I think here, in-house legal teams are in a really good position, because there's the opportunity to share within the team, share within the organization, share within the sector that the firm is in, and share within the profession, and also across professions, because these are questions, these are challenges being asked in so many places. As with managing culture, so how we apply AI. And these aren't dark arts, these are collective challenges. And there is so much to learn here, and where I think the legal profession, in-house legal teams can really play a big role. And this cultural aspect is only going to get more important as AI continues to develop. As we move into agentic AI worlds, where the power, the responsibility is not only in making the decisions, but it's in setting the decision, the choice architecture, in setting the guidelines, and serving and working in workforces that may be hybrid, human and agentic. We absolutely need, in these situations, really good in-house legal minds, and we need really good cultures. And we need those good legal minds to be helping create and manage those cultures, so that we're in environments where it's not only easier to do the right thing than the wrong thing, but really easy to do even better things. And then we get all those opportunities. Thank you.
Thank you very much. Take the mic. Thank you very much. Fantastic contributions from the panel. Just quickly picking up a couple of the points. One is risk, which if anyone working in business, whether it be the paid or the non-profit area, risk is definitely there, and AI presents both opportunities and risk. The next one is process, and process includes leadership and speaking up and challenge, testing things, and that picks up the points about the issues about hallucination. And just picking up one other point, I go back to Hannah Arendt, and we see this all too dreadfully in the post office case of absence of thought, no idea of putting yourself in the position of the other, no idea about your role and what you should be doing. And this key issue which came up throughout the hearings and in our other areas, the transference of accountability. It wasn't me. I was just a cog in the system. I just did what I was told, no matter how senior that individual might be. Can you imagine what that might be if the transference of accountability is to an inanimate tool, AI? So picking up those themes, it would be great to get the views and questions from the in-person audience here. And I will also pick up some points that have come through online as well. So if you put your hand up and say you'd like to ask a question, if you can say who you are and where you've come from in terms of your organization, if you are from an organization, they should be very useful. I think we've got two at the front here. Thanks very much.
Thank you very much, Chandela from the Government's Innovation Agency. My question is around speed. So ultimately, the pace of AI is just almost mind-boggling in very simple terms. So if you're thinking about process, it wasn't my fault, something's happened. I'm wondering where your thoughts are on, okay, we had that terrible thing with the post office, but just generally, our politicians are not equipped in the best will in the world to legislate at a speed or an intensity. What are, apart from words like guardrails, what can you actually do? Because at the moment, it strikes me is that if somebody gets a briefing on Monday, by the time they've left that briefing, things have moved on and they're not, for want of a better word, in touch with the full facts.
Thank you, right. So speed in terms of AI, speeding up things. Can we pick up the question next door and then we'll take the two questions together?
Okay. Hi, everybody. Excellent panel. My name is Luis Lancos, and I'm a founder of an AI company that for financial services, and we work in agentic AI. So this is something that I work day by day, and I live day by day. I actually have 2 points, 2 questions here that I think are very, very relevant. The first one is regarding the accountability. And I absolutely subscribe the accountability, especially with agentic AI coming, where they have to make decisions, and we need to have serious discussions about accountability on that. But there is one aspect that I didn't hear, which is around AI, which is agreeability. The AI has the tendency to be very agreeable with, and that has a deep impact, for instance, in the law system. So whatever you're going to say to the model, it will not fight you back like a person, right? And that can actually induce behaviors and bias, because the person, without even knowing, can force the AI then agree with the response. So I would love to hear that angle and your views. And my second question, it's a fundamental question and something that actually keep me worried. When we start this journey of LLMs, many companies and many organizations were trained their own LLMs, and I'm sure BMW also had that. But we live in a world that, because of the massive amount of data and the speed of change, as Chandila was saying, we see a few models now becoming the standard models within the organizations. And that has some interesting dangers, right? And so if we pick up OpenAI, they have, I think, 300 million users or something like that. And I met some people, and I know it's a bit a sideline, but you will help me to make the point. I met a few users that says, oh no, I don't need therapists now. I use AI for therapists. This is very significant, because what we are facing is these models that are pre-trained and will power legal systems, will power social systems, will power almost everything. They have now the power to create what I called AI-induced human drift, right? So if we manipulate the training data, the pre-trained data, we can manipulate without even people noticing the behavior, the social behavior, the conduct, the professional behavior of people. And the danger here is because we have a super concentration of 2 or 3 models that drives the whole conversation. So my question to the panel is how we actually can put in place mechanisms whereby we control this danger. And I would like to finish one sentence. If I was a tyrant and I wanted to dominate the world, I wouldn't even bother with weapons at this moment. I would just go and probably buy OpenAI, yeah, and start to train the models as I want, precisely to induce this human drift that the models will cause.
Thank you. So we've got sort of 3 questions. One in terms of AI speeding up decision making, one on accountability, and the other one about AI creating this this drift which humans don't realize. Who wants to pick up some of these questions? Okay, so
I don't know if this is answering the whole question because it's a big question, but the way that AI is developed can obviously be shaped quite a lot by how it's designed. And there's a good example that the little blog that I was talking about earlier picked up, which was in testing a particular AI tool, which was being used in a company that produced medicines. It had been scripted to act, quotes, boldly in the company's best interests. And when it spotted some falsified clinical trial data, it drafted an email to the FDA, the medical regulator in America. And no one asked it to do that. It just did it. And so that's an interesting example that Ryan talked about, how you could actually use that in AI systems that you want it to come up with those sort of things. You wouldn't have it send it straight off to the FDA, but you would have it being flagged to General Counsel. General Counsel then decides what to do with it. And there would be lots of different ways that you could set up programs to do that. So I think it comes back to that point that I was sort of trying to emphasize, which is that AI will only be as good as we make it. And if we decide it's going to act ethically, then we can make it act ethically. I might pass that to the competition lawyer.
Right, so it's more better all up.
Maybe just to pick up on that last one, because it's really a key point. And I think this is a question about democracy, the future of democracy. And there are quite sophisticated conversations ongoing. I've been following the EU approach to this for the past few years, where you have attempts through legislative instruments to create fair and contestable digital markets, not simply thinking of this as competition as an aim and a good in and of itself, but in recognition that control over the underlying infrastructure, control over the data is itself a source of power. And once states become dependent on particular digital infrastructure, I think this is potentially extremely problematic in the long term. And the question I probably phrased very obliquely in my opening comments was, I'm curious to think how companies are also thinking about this, because to some extent, reliance on, for example, Amazon Web Services or whatever it is indispensable from a company's perspective in order to operate. And so the query then becomes, to what extent the scope for regulation in order to ensure that that dependence doesn't become problematic for competition, but also for other things that we value in society. maybe just to because there are so many kind of points raised, I think, in these queries, but when we go to the point around agentic AI offering care services or health advice, or these or intersecting or interacting in these very sensitive areas, there is a query, and the law to some extent has tried to triage this by saying we shouldn't have purely automated decisions that have a legally significant effect on individuals or a similarly significant effect. And I think there is a kind of a societal call that involves huge amount of ethical considerations about where we think it is legitimate and appropriate to use AI tools in order to facilitate things, and where actually we kind of draw a line and say, here we require human judgment and human input.
Thank you. I've got two questions. Well, actually got a number of questions that have come through online, but I can probably summarize them as two questions, which closely link up to the ones that were already been asked. One is the risks that lawyers face in becoming too dependent on AI over time. And the other one, lawyers may breach their duties to their client in disclosing information essentially to the AI that actually is proprietary to a particular client. This would apply both in-house, I assume, and also in private practice. I don't know. Philip, I think you putting your hand up to speak.
Yes. So in terms of data that you're entering into an AI platform, it's a significant problem. And I think from an in-house perspective, you've got to look very carefully at what the contracts you have with the entities supplying that system to you to make sure that there's cast iron protection, that data is not going to be used to train that system, because the data you may be entering may be used as training data for that system, and you might find future outputs will be influenced by that. So that is a significant problem. I missed the first.
Oh, the lawyers becoming too dependent on AI.
Too dependent.
We're not there yet.
It's a significant problem, and we're going to have to look very carefully at how lawyers are trained. And I think that's where it starts. We're starting to see law students who are incredibly dependent on ChatGPT in particular and other platforms. And I like to liken it to learning to fly. If someone is flying a transatlantic flight, they're probably using autopilot. But this is an individual who's gone through an intensive training process, starting on aircraft which do not have autopilot equipment. They learn the basics, they learn the fundamental. And then from time to time, they practice their skills, and autopilot is not used at all times for flying that plane. And I think we're going to have a very similar approach with the use of AI by lawyers, because there's a significant problem that if we get too dependent on it, we will lose our critical skills and our ability to execute the equivalent of the landing and takeoff manually. And likewise, in our training, we're going to have to ensure that there are opportunities for the development of those skills manually, such that you can check the output and ensure that it's not simply full of hallucinated errors. And it is a real problem that we're going to have to face as a profession.
Picking up, thanks very much, and picking up Orla's point right at the beginning, when the internet fails, as it happened to do this morning, what do we do? Can I just check, Alison and Raphael, do you want to say anything before we close?
No, it was just very quickly, I think on a number of those questions, it really does reinforce for me the importance and the opportunities for and challenges for the professions. I mean, every profession, but in this context, because clearly the regulation, the rules will always lag behind change. You know, it's just a given. It's not something, to think about. And the professions formally may also lag, but they have a real role in facilitating the types of peer discussion, arguments, debates, again, within the profession, but across professions, that can help give guidance to individuals and sort of flag things for concern. And also in that training context, again, that peer pressure, that respectability, that importance is such an important factor in this. So I think, a lot sits there, and then the regulations absolutely will lag.
You have the final word. You understand? I've just picked up one question that I've had come in. One online question, which was essentially about detection systems for law students. How do let's call it assessors ensure that law students aren't cheating with AI? A difficult question. All I can say is that I can speak for the laws faculty at UCL. We've gone back to old-fashioned exams, a bit like I mentioned right here, pen and paper in an old-fashioned exam hall, maybe not as old as this particular hall, but certainly one where you are faced with having no access to any electronic means whatsoever, let alone AI. Thank you very much. And may I take this opportunity to thank our panel. And finally, thank you very much to Middle Temple, to Stuart and colleagues for hosting us. Thank you.